Good afternoon, everybody. My name is Haitham Amin. I go by Sam. I'm an attorney here in San Francisco, California. And today we'll be discussing the issue of bail in a criminal context. Before we go any further, I would like to invite you, if you haven't already done so, to please follow me on YouTube, subscribe, like, comment, follow me on my other social media accounts. If you have a specific question, feel free to private message me. Of course, you can write your question in the comment section, and I will also address it at the next video opportunity. Back to bail. How does one get bail? Well, when one is arrested for a crime, generally speaking, a serious crime or a felony or certain misdemeanors, the court will set bail, deny bail, or schedule a bail hearing where the defendant, through counsel, usually an attorney, is able to argue for reduced bail. The bail is usually in the form of a dollar figure or collateral, like real estate. The most common form of bail is obtaining a bondsman, which is a person the defendant will pay, usually a percentage, 10%, 10 to 8% of the total bail amount, and the bondsman will then put up the rest of the money. With respect to bail, the court in California, the California Constitution, specifically Title I, Section 12, and recent case law out of San Francisco and the California Appellate Court, and Humphrey is the case name, have outlined what the court should consider when granting bail to a defendant. Generally speaking, there are certain crimes where bail is not going to be granted, such as capital crimes, murder, serious felonies, sexual assault related cases, etc. And in order for the court to decide whether or not to grant bail, two main issues will need to be analyzed by the court. The first issue is whether there is a risk to the community of the defendant is released. And the court will ask whether or not the defendant, or rather the court will look at whether or not the defendant is charged with a serious crime, serious violent act, or threatened another with a great bodily injury. And the court has to make a finding by clear and convincing evidence that releasing the defendant will create a substantial likelihood of harm to others. The second equally important criteria the court will analyze is the flight risk. And in order for the court to assess whether or not money bail will address a flight risk, the court is required to look at, one, whether the defendant has the ability to pay, and it cannot be a wealthy versus poor kind of argument. The bail has to be proper, and it cannot discriminate based on wealth. So the court will look at whether or not the defendant is able to pay and will engage in an analysis, it's a case-by-case analysis, to see if they can narrowly tailor a dollar figure to make it affordable, or to rather guarantee that the defendant will not flee or skip out on his or her next court date or court hearing. The court is also required to show, or rather make a finding by clear and convincing evidence, that there are no other non-monetary alternatives to accomplish the task of guaranteeing defendant's attendance at future court hearings or trial. For example, if the court is able to order non-monetary alternatives, the court is required to do so, such as scram home confinement device like an ankle bracelet, alcohol bracelet, curfew, search and seizure of the person, his or her vehicle, his or her home, more recently his or her cell phone. Stay away order from complaining witnesses or so-called victims. Stay away from his or her house as well, the victim's house. It's usually accomplished by a criminal protective order. So there are other alternatives that the court can impose that would be less restrictive and accomplish the task of keeping the public safe and guaranteeing the defendant will appear at her or his next court date or trial. Now, these are the two main criterias. If one is granted bail, one is required to abide by certain criterias in addition to what I have outlined earlier in the conversation. Generally speaking, you're supposed to abstain from alcohol and drugs, including marijuana. Generally speaking, you'd have to check in with the probation officer or probation office. There could be random drug testings. So depending on the county, depending on the seriousness of the offense, the court may tailor a specific criterion that will be imposed upon the defendant if bail is granted. With that being said, I hope you enjoyed my video. If you have any specific questions, feel free to message me privately. Again, feel free to please subscribe, like, comment, follow me on other social media outlets. I try to put out as many videos as I can, generally 1 or 2 a week. Sometimes it's tough for me to do that when I'm in trial or if I have a heavy load during any given week. So I do my best putting out these videos, and I hope you enjoy them. With that being said, I'd like to thank you for watching and spending time with me. Take care. Being the only person that's advocating in the courtroom on behalf of the accused is a humbling feeling for me. I believe in the tenets of the Constitution, which is innocent until proven guilty, and that carries from day one until the trial date.